Rarely does a single sentence so completely crystallize a debate as the first line of the court order in Tennessee versus Cardona. The case involves the attempts by the Biden administration's Department of Education to rewrite Title IX's protection of women in education and their access to competitive sports. The single sentence? There are two sexes, male and female, period. That one sentence is the foundation of Judge Reeves' injunction against the United States Department of Education's attempt to ignore biology, rewrite the law, and set back women's rights by decades. So we'll take a look at this injunction next on the Constitution Study.
Love the neighbors and have a few good friends. Every day we're everyday Americans. Oh, every day we're everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study, where we read and study the Constitution. We teach a rising generation to be free. Now, I keep looking at reality versus what we want. There's what there is and there's what we want, and sometimes they don't match. And how we deal with that says a lot about us and how we interact with others. It's a fundamental question here in this case, Tennessee versus Cardona. But before we get to that, I want to remind you, you can find out more about this article and others at the website constitutionstudy.com. I'll talk more about the website at the end and maybe how you can support the work that we're doing. But realize there's a place to go, and more importantly, there's a place to ask questions. You ask a question, I'll do my best to answer it. So consider that at constitutionstudy.com, and let's get to this question of reality versus desire, Title IX, in the case Tennessee versus Cardona. The transgender movement boils down to a question of subjective versus objective. If someone believes they are not the gender they were born, is the problem with their body or with their mind? This is the fundamental question, and by extension, the fundamental issue which society is being asked to decide. In the middle of this, the Biden administration has created its own moral quandary, revolving around the question of subjective versus objective. Does a law mean what the language objectively says, or does it mean what a person subjectively wants it to mean? That question is what the case State of Tennessee et al. Versus Miguel Cardona et al. Is all about. From the injunction, we read, this case concerns an attempt by the executive branch to dramatically alter the purpose and meaning of Title IX through rulemaking. But 6 states, an association of Christian educators, and one 15-year-old girl object. As they correctly argue, the new rule contravenes the plain text of Title IX by reading sex to include gender identity, violates government employees' First Amendment rights, and is the result of arbitrary and capricious rulemaking. If the new rule is allowed to take effect on August 1st, 2024, all plaintiffs will suffer immediate and irreparable harm. This case revolves around Title IX of the Education Amendments Act, signed into law by then-President Richard Nixon on June 23, 1772. The law states, no person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any educational program or activity receiving federal financial assistance. While the law does provide some exceptions, for the most part, any education program or activity receiving federal financial assistance is barred from excluding people from participation in or the benefits of an education program or activity based on their sex. In 1974, Congress passed an amendment to Title IX introduced by Senator Jacob Javits of New York, clarifying its application to intercollegiate athletics. The amendment directed the Department of Health, Education, and Welfare, the Department of Education's predecessor, to issue a regulation that contained, with respect to intercollegiate athletic activities, reasonable provisions considering the nature of a particular sport. Notably, this amendment further cemented that Congress intended Title IX to cover athletics at all levels for both males and females at schools receiving federal funding. As I noted at the beginning, Judge Reeves opened this memorandum with a fundamental truth. There are two sexes, male and female. This sentence had an interesting footnote. The defendants made this concession during oral arguments on the plaintiff's motion for injunctive relief. The parties have agreed to little else. Even Secretary Cardona and the U.S. Department of Education agreed there are only two sexes. Yet they continue to promote the idea that sex somehow includes gender identity. Now, Judge Reeves later describes some of the discriminatory impact of this view. As a practical note, ignoring fundamental biological truths between the two sexes deprives women and girls of meaningful access to educational facilities. In intimate spaces like bathrooms and locker rooms, students retain a significant privacy interest in their unclothed bodies. This necessarily includes the right to shield one's body from exposure to viewing by the opposite sex. After all, in the words of former Justice Ruth Bader Ginsburg, the integration of an all-male military institution would undoubtedly require alterations necessary to afford members of each sex privacy from the other sex in living arrangements. That's from United States versus Virginia, by the way. This interest in protecting bodily privacy is sex-specific because of, not in spite of, the different male and female anatomies. But at a minimum, students of both sexes would experience violations of their bodily privacy by students of a different sex if the final rule became effective. Nonetheless, despite society's enduring recognition of biological differences between the sexes, as well as an individual's basic right to bodily privacy, the final rule mandates that schools permit biological men into women's intimate spaces and women into men's within the educational environment based entirely on a person's subjective gender identity. This result is not only impossible to square with Title IX, but with the broader guarantee of education protection for all students. While the question of personal spaces was discussed at length in this memorandum, a significant First Amendment issue was also raised. The final rule also has serious First Amendment implications. The rule includes a new definition of sexual harassment, which may require educators to use pronouns consistent with a student's purported gender identity rather than their biological sex. Based on the pervasive nature of pronoun usage in everyday life, educators likely would be required to use students' preferred pronouns regardless of whether doing so conflicts with the educator's religious or moral beliefs. A rule that compels speech and engages in such viewpoint discrimination is impermissible. Judge Reeves referred to a Sixth Circuit case, Merriweather versus Hattop, to support his decision. The Sixth Circuit's opinion expressly recognizes that titles and pronouns carry a message, and compelling someone to use preferred pronouns communicates the message that people can have a gender identity inconsistent with their sex at birth, which led Judge Reeves to conclude, it is unclear how the government's articulated position can be seen as anything less than a tacit endorsement of a content-based heckler's veto. So long as the offended individuals complain with sufficient vigor, the refusal to abide by preferred pronouns can be deemed harassment and exposes a recipient of federal funds to liability under Title IX. Speaking of federal funding, it should not be a surprise that the leverage the federal government wields behind this rule is money. The states next cite the federal funding they stand to lose if they do not comply with the final rule when it goes into effect on August 1. The states presented the testimony of David Thurman, State Budget Director for the Tennessee Department of Finance and Administration. Thurman explained how Tennessee's yearly budget is developed, including a budget for the Department of Education. Thurman reported that the education budget for fiscal year 2023 was approximately $8 billion, with approximately $1.8 billion comprised of federal funds and approximately $1.5 billion coming from the U.S. Department of Education. As Alexis de Tocqueville once said, the American public will endure until the day Congress discovers that it can bribe the public with the public's money. This regulation is simply the latest in a long train of examples of how Congress has discovered that it can bribe the public with their own money. I only wish Judge Reeves had gone into this in more depth. While Judge Reeves talks about the impact of the loss of such funding, no mention is given to the fact that Congress has no constitutional authority to spend money on education. Neither does the Constitution give the executive branch the authority to use tax money to intimidate states into following their political agenda. Once again, we see the bribe offered by Congress being used to manipulate and intimidate the states into complying with the political wishes of the federal government. Judge Reeves comes to several conclusions, none of which are supportive of the actions of the U.S. Department of Education. First, Judge Reeves castigates the DOE for ignoring the concerns of parents, teachers, and students, along with their basic privacy and safety interests. It is an inescapable conclusion based on the foregoing discussion that the department has effectively ignored the concerns of parents, teachers, and students who believe that the final rule endangers basic privacy and safety interests, rather than address the evidence provided by the plaintiff states and others during the commenting period. The department throws its figurative hands in the air and says, "Too bad." But as the United States Court of Appeals for the Fifth Circuit has underscored, bare acknowledgement of possible issues a rule will create is no substitute for reasoned consideration, especially when the regulated subject is one of extraordinary consequence. The department has not identified significant evidence indicating that its motivations here are rooted more in sound considerations accounting for the serious privacy and safety interests than in the political preferences of an outcome-oriented rule. Based on this analysis, the final rule is arbitrary and capricious. Next, Judge Reeves points out how the DOE has far exceeded its statutory powers. Title IX of the Education Amendments of 1972 was intended to level the playing field between men and women in education. The statute tells us that no person shall be subjected to discrimination under any education program or activity receiving federal financial assistance on the basis of sex. However, the Department of Education seeks to derail deeply rooted law with a final rule that is set to go into effect August 1, 2024. At bottom, the department would turn Title IX on its head by redefining sex to include gender identity. But sex and gender identity do not mean the same thing. The department's interpretation conflicts with the plain language of Title IX and therefore exceeds its authority to promulgate regulations under that statute. Lastly, Judge Reeves points out that the rulemaking was arbitrary and capricious and devoid of reasoning. Additionally, the department's actions with respect to this rulemaking are arbitrary and capricious. The department fails to provide a reasoned explanation for departing from its long-standing interpretation regarding the meaning of sex and provided virtually no answers to many of the difficult questions that arose during the public comment phase. Notably, the department does not provide a sufficient explanation for leaving regulations in place that conflict with the new gender identity mandate, nor does it meaningfully respond to commentators' concerns regarding risks posed to students and faculty safety. All of this leads Judge Reeves to his final order. Based on the foregoing analysis and discussion, it is hereby ordered as follows. The motion for a preliminary injunction stay filed by Tennessee, Kentucky, Ohio, Indiana, Virginia, and West Virginia, and Christian Educators Association International and AC are granted. The United States Department of Education and Miguel Cardona, Secretary of the United States Department of Education, along with their secretaries, directors, administrators, and employees, are enjoined and restrained from implementing, enacting, enforcing, or taking any action in any manner to enforce the final rule, non-discrimination on the basis of sex in education programs or activities receiving federal funds and assistance, which is scheduled to take effect on August 1st, 2024. This injunction is limited to the plaintiff states of Tennessee, Kentucky, Ohio, Indiana, Virginia, and West Virginia, and extends to intervening plaintiffs, Christian Educators Association International, and AC in these 6 states. The preliminary injunction is filed, and the Department of Education is enjoined and restrained from putting their final rule into effect. Based on what I've read, this is a constitutionally sound decision. While some may not be happy, the fact that this injunction is limited to the plaintiff states actually comports with both legal standards and the Constitution. District judges issuing nationwide injunctions are the actual violation of their oath, since when Congress created these courts under Article 3, they limited them to a specific region. Also, under our Constitution, courts do not make laws. Based on that and basic legal standards, their decisions are limited to the parties to the case, which is exactly what Judge Reeves has done. It would not surprise me if the Biden administration appeals this case. I wonder if the circuit and possibly Supreme Courts will come to such a constitutionally sound conclusion as Judge Reeves has. Score one for the good guys in this transgender insanity. I'm not saying it's going to hold forever, but we should take the win while we've got it. Judge Reeves made a constitutionally sound, scientifically based, biologically obvious conclusion. He drew that conclusion from facts and evidence. Rather than promoting an agenda, he followed the law, and I appreciate that very much. As I said, I expect the Biden administration to appeal this to at least to the Circuit Court, if not all the way to the Supreme Court. Whether they'll come up to the same constitutionally sound argument, I don't know. Now, there's another case that has a similar outcome, which, since they're in agreement, right now I don't see a reason for the Supreme Court to step in. The point is, at least in these 6 states, sanity reigns. Makes me feel bad for the other 44 states that may not have such a constitutionally sound judge issuing such constitutionally sound injunctions. All we can do is work and pray to find better representatives that will place better judges on these courts so that we can end up with better decisions. Now, if you want to learn more, if you want to check out my quotes, make sure I'm quoting this stuff right, well, you can find this article and many more at the website constitutionstudy.com. All my articles are there with all the links I have to the supporting documents. You can also find videos. You can find other articles. There are links to my radio program. There's even breaking news. I've started posting news articles on there. It's all there for you to check out. There are mailing lists for each of those as well. So if you want to get an email whenever I release a new article, a new video, maybe a new radio program, or a new breaking news item, just sign up for the mailing list. If you'd like to support the work that we're doing here, well, then head to constitutionstudy.com/shop. That's where I sell my books, t-shirts, mugs. It's where you can just donate to the cause if that's what you want. It's a lot of work to put these videos on, these radio programs, all the other stuff that we're doing. Takes a lot of work, takes a lot of time and effort, and yeah, it takes a fair amount of money too. So if you can help, I'd appreciate it greatly. Best of all, if you have a question, just contact me through the website. There's an Ask a Question button right there at the main menu. Ask a question, I'll do my best to answer it. If you'd like me to answer it on the radio program, there's a checkbox for that as well. So all the places to contact me are focused right there at constitutionstudy.com. I hope you enjoyed this episode. I hope you enjoyed the way I put this together. And I hope you come back and join us for the next Constitution Study.